Right. Well, we will get started. Thank you for joining me, Alec. For those of you who don't know me, I'm Kira Lerner. I'm a staff reporter at The Appeal. And Alec is the founder and executive director of Civil Rights Corps, a group that challenges injustices in the legal system and has won a number of really important federal court victories in lawsuits challenging cash bail systems, and the use of fines and fees in the court system, and much more. And he's a former public defender and now the author of a new book, Unusual Cruelty: The Complicity of Lawyers in the Criminal Justice System. And I'm really excited to have Alec here today. He's becoming a regular voice around The Appeal. He was recently on The Appeal podcast talking to my colleague, Adam Johnson. So I encourage you to check that out if you haven't listened. But I think we'll just kind of build off that conversation and talk about some of the other really interesting topics that they got to dive into on that podcast. So welcome, Alec. I think we'll start out. The focus of your book is on how much of the criminal justice reform movement right now is, as you describe it, superficial and deceptive and therefore dangerous. You write that it's superficial because most of the proposed quote unquote reforms would still leave the United States as the greatest incarcerator in the world. Can you talk about how you think we've gotten to a place where much of the discussion when it comes to reforming our legal system is, as you describe it, incremental and deceptive?
Yeah, sure, thanks. And hey, Kira, and thanks to Nick for organizing this and for having me, and thank you for reading the book, Unusual Cruelty. So I think it's really important to understand that most of the people that are talking about reform, like when I go around the country and I talk to local leaders, state, national officials, most of those people are actually pretty happy with how our society looks. They've been persuaded, or at least they've been pushed by other people who are persuaded to at least articulate in public some level of concern about the excesses of our criminal punishment bureaucracy, but they generally like the way that our society looks. So they're not interested in talking about changes to our society or to our punishment bureaucracy that would involve pretty significant changes to, let's say, the distribution of wealth and power, or to white supremacy, to sort of the big fundamental causes of mass incarceration and the punishment bureaucracy generally. And so as a result, because they don't actually see radical problems with our society, their reforms, the proposals that they make in every realm, but particularly now for this purpose of this discussion in the criminal realm, those reforms are going to reflect their diagnosis of the scope of the problem. And so for many of them, it's about curbing some of the most grotesque flourishes of this system, which any reasonable person can understand has sort of become so metastasized that it's actually, completely outrageous, rather than like striking at the heart of many of the structures and systems and assumptions that created it. And so I think, one of the things that's leading it is really a lack of radical politics. More generally, a lack of a desire to make big changes to the way our society looks. And that's then reflected in those people's proposals for how to change the punishment bureaucracy.
Right. And so your book is focused on lawyers and the role that they have in perpetuating the punishment bureaucracy. You write that lawyers haven't confronted the suffering that they inflict, and they haven't bothered to seriously question whether there are benefits to this system. Why, when there could be a lot of different players to blame, did you decide to focus on lawyers?
Well, I just want to be clear. I mean, I think the book is really written not just for lawyers, but for anyone who wants to understand how this punishment bureaucracy was created, what functions it plays, and what kinds of things we might do as a society and as a movement to confront that at the level of real power. I end up talking a lot about lawyers for a few reasons. I mean, I think I try to focus my own advocacy on the people and the groups that I have the most knowledge about, and the people and the groups that I might have the most to contribute to. Like, I think all of us have to play our, there's a reason that I don't do a lot of writing and public speaking about injustices that are going on in different countries, for example, or, we're all all of us have to sort of understand and think about, like, where am I best positioned to make a difference? And for me, I think I'm at least in a decent position to confront and to talk to lawyers about the role that we're playing, not only in creating these injustices, but to a lot of public interest lawyers and public defenders and others, government lawyers, who maybe want to do something about the system, but are kind of trapped in sort of traditional elite public interest lawyer thinking about how lawyers have to be actually the people that lead that change rather than the people that are most directly impacted by it. And so there's a few different reasons that I want to talk to lawyers. One, we've played a special role in constructing the legal architecture of this system. Two, I'm best, perhaps, in position to talk to lawyers and law students and people that are working in the legal field. Three, I want to connect lawyers to these other movements and get them to understand that they actually there's a role for the law and for lawyers potentially in dismantling this bureaucracy of oppression, but it might not be the role that lawyers are taught in law school and the role that lawyers especially elite lawyers think that they should be playing in that movement.
Yeah. Speaking of lawyers, I see that we have at least a number of them on the call right now. And if anyone has questions directly for Alec, you can put them in the chat box, which you should see at the bottom of the Zoom screen. And I will make sure that he answers them at some point. As a journalist myself covering the legal system, and because you are talking to journalists as well, I'm thinking of the role the media plays when you kind of describe the role of lawyers as well. Can any of your critiques of lawyers apply to the media? And when you describe the need for a different cultural narrative, what role do you think the media has in shaping what that new narrative looks like?
Yeah, I think virtually all of the critiques that I'm making apply equally and with perhaps subtle tweaks to what we call the media, and particularly the corporatized media. So I think the vast bulk of what we think of as the media is very similar to the vast bulk of lawyers. Most of those people are engaged in an enterprise that furthers the sort of distributions of wealth and power in our society. The people that fund the media are the same people that fund most lawyering. Much of the media is directed at preserving existing understandings of and assumptions about the way our society looks and then rationalizing and justifying, right? So you can see that with the way the media talks about the coup in Bolivia, for example, or the way the media covers the criminal legal system every single day in every single local jurisdiction and nationally in this country. You can see that also in the way that lawyers talk. So I think there's a few parallels, right? One, the same entrenched aggregations of wealth are really the main players in both realms. Two, most of the people that work in both realms have fundamentally abdicated their responsibility to really challenge capitalism and white supremacy that created the mass incarceration bureaucracy, and in fact became complicit in it by furthering certain narratives and by not understanding the enormous pain that we're inflicting. And I write about this a lot in the third essay in the book. I sort of talk about a dual failure, an intellectual failure, which I think applies equally to the media and to lawyers. Part of the intellectual failure is a failure to confront the costs of mass human caging. So, people got very rightfully upset about child and family separation at the border starting about a year and a half ago. But separating children from their parents is what the criminal legal system does in 3,160 local jails all over the country. This is an urgent problem. We've allowed our jails to become grotesque torture chambers where people are not only deprived of sunlight and fresh air and toothbrushes and toothpaste and hygiene products, but they're given infectious diseases, they're raped and beaten, they're deprived of basic medical and mental health care. I mean, these are urgent situations, and neither the media nor lawyers are treating the costs to human beings and their bodies and their families urgently, largely because of who we're doing it to, the vast majority people of color and poor people. So there's an intellectual failure. Then there's what I think of as more of like a moral failure, a failure to organize and to stand up to these systems for a variety of reasons. I think the incentives are maybe a little bit different in the media and in the law, but like the most of the incentives are to take certain jobs and to work for certain organizations and to not take certain positions, which put you at odds with the power structures within those fields. And so slowly what happens is we all become desensitized to the cruelty and brutality of this everyday system. And we all organize our jobs and careers in such a way that doesn't actually fundamentally challenge it at a real powerful level. And so I think there's a intellectual failure to understand the cost of the system, a secondary intellectual failure to especially, this is one especially applicable to journalists. Journalists have never required the criminal punishment bureaucracy to set forth any empirical evidence that it's doing any good, that it's even furthering at all the main goals that it tells us it has, like making us safer, right? Like, there's no evidence of that at all. And journalists have basically, and lawyers, in court cases all over the country and in media articles, nobody ever talks about the fact that there's zero evidence of these long sentences and the policing, that these are actually the ways that you might confront these really public health kind of issues and create any kind of like safety and holistic sense of well-being and human flourishing. So that's intellectual failure. And then we haven't operationalized our resistance to that system in any way that's even remotely effective. That's the moral failure, I think.
Yeah. Another kind of facet of the book that I found really interesting was your discussion of how all of us who work within the legal system have become desensitized to the pain that it inflicts. And you describe some really awful and traumatic conditions that you've seen both your clients and other people subjected to throughout the legal system. At one point, you described young Black children who we restrain in chairs in the basement of a DC courthouse, and kind of no one had really given that much thought. What kind of impact do you think it has on the legal system when everyone involved is desensitized to these types of things?
Yeah, so I mean, that example I think is a really good one. So when I got to the Public Defender Service in DC, considered by many to be one of the nation's premier advocacy organizations for indigent people who are charged with crimes, I went into the juvenile court, and all of the children who are detained for their proceedings are fully restrained in wrist shackles, waist shackles, and foot shackles. Obviously, this violates every international treaty and protocol about treating children. It violates like every single American court that's ruled on the question, which is not very many, which I'll get to in a minute, why we haven't actually complained about it in most jurisdictions. But every court has said that's also unconstitutional. And nobody had even objected to this practice, as far as I could tell, in DC in many, many years. And these proceedings are entirely closed to the public. I actually never saw a white child the entire time I was there for 3 years at the Public Defender Service. And our lawyers, you know, we started objecting to it because it is a shocking thing. Like, imagine like coming home from a night out, like, and the babysitter has like fully restrained your child in metal chains. You'd be very upset. You might even want to press criminal charges against that person if you were, you know, someone who likes to press criminal charges against people. And I think many people in our society would feel you were justified in like being outraged. And yet all of those same people who would have had that reaction were doing this to children. And I'm talking about 8-year-olds, 9-year-olds, children who've been abused and neglected, who've suffered enormous trauma, children with very serious intellectual disabilities, physical disabilities, autism. I mean, it was just a shocking thing to witness. And when we finally started making these objections, the judges were basically completely indifferent to them. They had become so programmed that they didn't even think this was a problem anymore. And the same thing is true, unfortunately, with the way we handled much more routine public kind of proceedings, like bail proceedings, for example. I think the entire time that I was at PDS, and definitely the entire time I was at the Federal Defender's Office, I don't think any lawyer in our office filed a bail appeal. I don't think any lawyer in our office filed a request for bail pending appeal. You know, if you're the governor of Virginia and you're convicted of federal felony offenses, your lawyer files a motion for your release pending appeal. And for indigent people, when I got to PDS, it took about 3.5 years from the end of their lower court case until their appeal was over. And so PDS's appellate division, exceptional. We won about 33% of our cases. But if your sentence was less than 3.5 years, you would have served the whole thing by the time you won your appeal. And yet we didn't even bother to ask for our client's release. We didn't even bother to file appeals when our client's pretrial release was denied. And I think it slowly filters its way throughout the system when all of us, even those of us who are exceptional advocates in every other way, or at least many ways, when the person who's supposed to be telling our client's story and fighting for that person, when we don't even value their pretrial liberty enough. And this is something that I've thought about a lot, when I was a trial public defender, never once filing a bail appeal. It kind of haunts me that you can, all of us, even those of us who think of ourselves as people who care a lot about these issues, the system is so overwhelming and totalizing, and its propaganda is so relentless that it's very, very hard to fortify your mind against that relentless propaganda. And that's where I think the media and lawyers need to come together. We need to make sure, and I talk a little bit in the book about ways we can do this. And we certainly at Civil Rights Corps, we try to do this in a number of ways I can talk about if you're interested. We try to always make sure that we're resensitizing ourselves and each other to the incredible cruelty and brutality that the system is inflicting.
Yeah. Kind of a related point, I was interested in your thoughts on the importance of the language that lawyers use in court, and the problems with labeling people with things like suspect or defendant. I know journalists often grapple with kind of the same issues. I was recently at a forum where a journalist referred to the audience of formerly incarcerated people as felons, and there was a backlash, and the journalist kind of pushed back and was like, no, that was the word I use as a journalist. And I think, just in my opinion, this is something that journalists should think about more critically, and how the language they use affects people involved in the legal system. Is this kind of part of what you're talking about when it comes to humanizing people, and how else do you think lawyers and journalists can work to humanize people beyond just thinking about language?
Yeah, I think this is an absolutely vital point. I want to make several related points. So it's not just the language. It's about creating space and moments in the context of legal representation that can change the narrative around what we're talking about. So it's not just the words you're using, it's the kind of space you're creating. So let me give you an example. When I started doing a lot of federal criminal defense of illegal reentry cases, which is a federal felony charge, it's basically a felony to be born in a different country and to cross an imaginary political boundary to a different country if you've been deported from that country. I mean, it's kind of wild to think about caging human beings for crossing imaginary political boundaries, but that is a crime, and it's one of the most commonly charged federal crimes. And I was doing a lot of those cases, and one thing that our office started doing was in those sentencing hearings, we started several things. One, we would have our clients submit artwork that they had made to the court. And we talk about that artwork at the sentencing hearing. And it sort of changes the dynamic a little bit about like, these judges were giving very harsh sentences prior to this initiative in these cases. Another thing we did was we started talking in all the sentencing memoranda about can you still hear me? My screen just kind of.
Yeah, you're good.
Okay, good. We started talking about American intervention in Latin America and what role this country had played and for what reasons in destabilizing and destroying a lot of the communities that our clients were coming from. And third, we started doing really simple things like standing up at the beginning of the sentencing hearing and saying, Your Honor, I'd like you to order the United States Marshals to unshackle my client so that she can hug her child one last time before she's taken away and deported, right? Creating that space where a mother hugs her daughter in court, right? A little thing like that, actually totally, and then having the person, if they want to, talk to the court about their life. Little things that they disrupt the assembly line. They change the sentencing hearing from a 5-minute standard rote procedure to a half an hour, 45-minute, hour, 2-hour discussion about someone's life and how they ended up here and how they're so much like you, actually, Judge, like everyone else in the audience, like we are all the same. And in fact, we have done things as a society that have deeply traumatized this person, and we have responsibility for it. And we started to get lower and lower sentences in all of these cases. It doesn't happen right away, right? But and then the language that you use, it like you pointed out, the system is constantly trying to use the language of police reports. There's a very real reason that police reports look very different from poems, right? Police reports are all about dehumanizing people so that we can cage them without feeling a lot of cognitive dissonance. They use like these words like suspect, and the way they use verbs and nouns. I mean, anyone who's read a police report knows what I'm talking about. It's meant to depersonalize and dehumanize. And poems are exactly the opposite, right? I always tell people, like, I would much prefer, instead of handing a legal brief in most of our cases, I'd love to hand a piece of artwork or a poem to the court, because there's a different way of communicating human stories. And so one thing that we try to do a lot of is to collaborate with journalists and artists, painters, other kinds of visual artists, poets, to tell our stories in a different perspective, in a different way, and to have our clients tell their stories. So we have a poet in residence and an artist in residence in the Civil Rights Corps. We've collaborated with other poets and artists in some of our work. We try to do a lot of like work with journalists around like telling a story in a little bit of a different way. And so like when people who've been incarcerated or otherwise directly impacted, when they produce a piece of art or poetry about that experience, and it's a part of a campaign and a legal case and a public narrative discussion, it's really, really different from sort of the traditional lawyers like reading from a prepared statement from a complaint. Yeah. And so there's a lot of different components to it, but it's all about connecting with people on different levels to try to change the way they're processing this cultural and legal propaganda.
Yeah. Speaking of the poetry aspect, I just read Felon by Dwayne Betts, and he does something that stood out as really powerful to me. It takes a lot of Civil Rights Corps' legal documents and kind of blacks out a lot of the text. Can you talk about what he did there and the power of that?
Yeah, so that piece in Dwayne's book was actually from a really wonderful collaboration that we did with Dwayne Betts and Titus Kaffar, the incredible visual artist. Titus's paintings from the Jerome Project are actually on the cover of Dwayne's book. And so what happened was Dwayne took our complaints from Ferguson and Montgomery and Harris County, Texas, and Humphrey in California, and he created these redaction poems, really distilling these narratives, which we already tried to make more journalistic in each of those cases. Like if you go to our website and read the Ferguson complaint, it doesn't really read like your typical lawyerly complaint, but Dwayne sort of redacted a lot of words and distilled it to sort of what he thought of as the essence of the poems. And then they superimposed that redaction poetry over portraits of our clients and other people that Titus had made. And then they printed those portraits on paper that they made from, paper that was made from like prison clothing and other from people that Dwayne knew from the inside. And that was an exhibit at MoMA PS1 in New York. And the redaction exhibit then led to Dwayne including these redaction poems in his book. And hopefully what we're going to do is take the redaction exhibit on tour to jurisdictions where we've had these bail cases and these other sort of fines and fees cases, and have a series of public discussions around the artwork and its connection to the experiences of the people who suffered through these horrifically unconstitutional systems in each of those jurisdictions. So that's a kind of collaboration that I think opens up a space to engage with the issues in a different way that maybe is not as traditional for lawyers, but we hope can reach people and activate a different part of their mind.
Sure. I'll just remind people that if anyone else has any questions for Alec, you can put them in the chat function, and we'll make sure to pass them on to him. Another thing that kind of you talk and write about is how to balance harm reduction with the need to kind of fundamentally dismantle and question the entire system. And I know that's something you do at Civil Rights Corps. And I just wonder how you grapple with those two different things and find the right balance.
Yeah, so I mean, some people have accused me at times of being against incremental change or against harm reduction, just because I think our society needs a revolution that's going to fundamentally change many aspects of how we think and talk, and many structures that determine economic and racial relationships in our world. But I actually don't think that's accurate. And I think I'm all in favor. And basically everything I've done in my professional career has been incremental. The definition of incremental is like bringing cases in federal court, you know, and like, yes, our case in Houston is going to probably get 17 or 18,000 people out of jail every year in Harris County, but it's not abolishing the jail in Harris County. It's not abolishing the police forces. It's not abolishing the criminal punishment bureaucracy. It's not in any meaningful way challenging capitalism, right? So like, these are all like harm reduction incremental steps. I think the real question that we have to ask ourselves in our journalism and in our legal work is, do we have a theory for how this incremental change builds on itself, contributes to a broader movement that is actually seeking that kind of bigger change? Or is our incremental change being done in a way that's actually going to reify and perpetuate a lot of the same structures of oppression? And I think a good example of that is the first sort of bail reform movement that we saw in the 1960s. It was a movement that was led largely by ruling class elites. It was led by fancy judges. It was led by Bobby Kennedy, Lyndon Johnson, right? There was this moment, law professors, right? Liberal law professors, after years of sort of talking about this problem, you know, they were able to get the Federal Bail Reform Act passed in 1984. And it did some commendable things. It tried to end wealth-based detention in the federal court system. And the day that it was passed, about 24% of all federal criminal defendants were detained just because they couldn't pay money bail. So a serious problem, about a quarter of them. But today, as you and I are talking, the detention rate in federal courts is 72.4%. So we got rid of money bail in federal courts, essentially. There's still some issues and problems with it. But we tripled the rate of pretrial detention. And I think that's what happens when elites sort of control reform, and when you don't actually like fundamentally change the balance of power through like a social movement. So that, you know, that's one example. There's so many, and you could think of examples all across the criminal punishment bureaucracy that would reflect the same point.
Sure. And when you talk about social movements and when we think about solutions, who are you watching as examples of people or groups that are working to shape the legal system in effective ways?
Well, there's, I mean, hundreds and hundreds of groups and thousands of people all over the country that are working on these issues every single day in ways that are inspiring. I don't want to single out anyone in particular, but like, we have done a lot of work with these folks, and we try to basically ground our work in every single case, in every single local community, with people who are doing that work. Now, we often fail at that because it's very, very difficult for a few structural reasons. One, the ruling class in our society who basically controls philanthropic giving, the people that support Civil Rights Corps, the people that support the Justice Collaborative, that donor class has been traditionally reluctant to invest in, you know, strategies that are actually very likely to dismantle the way, you know, the way these systems actually function. They're much more likely to want to alleviate some of the most, you know, troubling symptoms of that system, right? So most philanthropic giving is not actually challenging like the aspects of our society that create the need for philanthropic giving. And so as a result, there's been a real divestment from actual grassroots organizing and power building in the society. The reason is that grassroots organizing is actually the thing, I think, that's capable of contesting power at the level that we need to contest it. And so when you're lawyers working on these cases in many of these jurisdictions, there's been a dearth of actual investment in in radical like organizing and power building. And so it can be very difficult sometimes to like, find in many places that you want to litigate, to find the people who are, like able to really hold the kind of big, like well-organized campaign that's really needed for fundamental change in that jurisdiction. Mm-hmm. And lawyers have tended to want, in the absence of that, in that vacuum, to want to step in and still bring the case and lead it themselves. And because, lawyers have more resources. And I think that has led to sort of a vicious cycle that has continued to block the development organically of that kind of work.
Sure.
Sorry, go ahead.
No, continue.
I was just going to say another thing is that lawyers are just taught to think that they should be making the strategic decisions and they should be the ones deciding where to bring a case and what to argue in the case and when to bring a case and all these things, right? And the pace of legal work differs from the pace of organizing work. And so it's hard to hire and recruit and train and teach lawyers and to change the way our brains work. And so I don't want to pretend like we or anyone else is doing this really, really well yet, but we are starting to have a lot of really great conversations and partnerships with organizers all over the country and to really like wrestle with these questions of how do lawyers fit into this movement ecosystem and what should be our role and how can we do this work in service of campaigns and movements that are actually led by people who are more directly impacted by these issues, and how do we get some of our work out of the silo of criminal legal reform and to start talking about some of these bigger systems. How does this fit together with labor organizing? How does it fit together with mental and medical health care and universal access to healthcare? How does it fit with environmental justice? There's so much work that needs to be done and connections that need to be made. And I think we're just now starting to really see a lot of that exciting work happening.
Yeah, I think that's kind of the exact note I was going to ask you to end on, looking forward at some of the solutions. If no one else has any questions, I guess I'll give you another minute to type any questions in the chat box if you have anything. But Alec, is there any major point in your book that you think you haven't mentioned today or that you think kind of hasn't gotten the attention you hope it gets?
I mean, well, I think there's a lot of really cool things in the book. I hope that people read it and take something from it. I think the first piece in the book is really meant to like offer my analysis of why the criminal punishment system exists, why it looks the way that it does, and to then apply that to a lot of the criminal justice reform movement, in particular the progressive prosecutor movement, and to a lot of the so-called criminal justice reformers that are promoting, I think, changes that are really designed to like preserve as much as possible the architecture of this system. That's why you see a lot of reforms and reformers, like just take Larry Krasner, for example, who's every year asking to increase the size of his own budget, or a lot of reformers who are asking to spend hundreds of millions of dollars on body cameras to watch police oppress people in the same neighborhoods, in the same ways. And then you're seeing a lot of, so I applied some of these lessons. So like, one big lesson is, and I really learned a lot over the years from studying groups like Critical Resistance and Miriam Kaba's work and other people who've been talking about, like, one of the big rules of thumb is like, we need to shrink the system. No more resources for jails and prisons and policing, right? We need resources into our communities. That's one big rule of thumb. Nothing that shrinks, nothing that increases the bureaucracy or preserves it, we should support. Another big rule is, how are these reforms changing? Who has control over what's happening? Another big one is, are they forward-looking or backward-looking? Are they looking at reparations? Another big one is, are they siloed in the criminal system, or are they actually looking to make connections between the criminal system and other systems of oppression? So I talk a lot about these issues, and I think it'd be really helpful for people to engage in that so they can get it. And I try to give examples of what might be really good types of reforms from worker-owned co-ops and other things like that. to various types of reparations involving the criminal system and various types of reforms that shrink the size of the system. And then the second essay in the book is really geared at younger students and young lawyers, college students, high school students, lawyers, law students, young lawyers, how to think about their legal career and how to think about what someone might do in a world of incredible injustice, and how to think about the urgency with which we should be approaching our lives and our work. And I hope people like it. And all of the royalties are being donated to an amazing organization called SE Justice Group. I encourage you to check out SE online and to support their work. It's an amazing organization that organizes women with incarcerated loved ones. So whenever you buy the book, none of the money will be going to me. All the royalties are going to SE. So encourage your friends and family. And the final thing is I'm offering free hugs to anyone who buys copies of the book for their friends and family. So that's something that you don't usually get with a book about the criminal punishment bureaucracy.
Yeah, we all need some more of that in our lives, whether or not we're in a courtroom. Well, thank you, Alec, for taking some time to chat with us today. I encourage everyone to check out his book and also the Appeal podcast from last week, which also featured an interview between my colleague Adam Johnson and Alec. I don't see any questions, so I think we'll leave it at that. But thank you so much.
Thank you, Kira. Talk soon.
Have a good one.